If his alibi was unacceptable, how is this okay? Hey guys, this is Jules with True Crime Reactions. Disclaimer, everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so today in the hearing, we heard and saw Bryan Kohberger stand up and say yes to being guilty of 5 charges when it comes to the murders of Ethan and Xana and Maddie and Kaylee, and also the burglary charge that they stacked on top of it. But then we saw and heard nothing new. We only heard that he filled out and signed some sort of factually written basis statements. And then we saw Bill Thompson stand up and read to us not only something that got us asking questions to begin with, but something that they've already deemed outdated, irrelevant, and no longer important to this case, the PCA information. They didn't have to come out and prove literally anything. The judge just said, present what you were planning to prove in trial. And they just basically gave a theory, even proving that even though they have all these so-say phone pings, they don't actually have any proof he was at 1122 King Road. Thompson said that today himself, and this is still where we are. I honestly just don't get it. And not because I'm stupid and don't understand, but because it doesn't make any damn sense. I was actually in the middle of editing another video about some other information that we found today that I found extremely interesting, but then saw that there was a new document and this just sort of took precedent. So I'm going to go ahead and get this one out tonight, but be watching for another video first thing in the morning, probably around 8:30, 9 o'clock. Just keep an eye out. The first one I noticed was that they actually posted the written factual basis. This is where Bryan Kohberger signed that he's admitting responsibility for burglary, admitting responsibility for Maddie, for Kaylee, for Xana, for Ethan, admitting responsibility to 1, 2, 3, 4, and 5. Okay? No further details. It's literally copy paste. The only thing they did was take it from count 1 to count 2 and change the name. That's literally it. What we also have posted to the public site, and I will have a link for both of these documents down in the description box, is the plea agreement itself. Now, I skimmed over the other document before hitting record. We pretty much know what everything was whenever the hearing was over, but now we have it in writing. So let's go ahead and take a look. The state of Idaho, by and through the Latell County Prosecuting Attorney's Office, the defendant, Bryan C. Kohberger, and the defendant's attorney, Ann Taylor, stipulate to the following plea agreement. The defendant will enter guilty pleas to the following counts: burglary, first degree for Maddie, first degree for Ethan, first degree for Xana, and first degree for Kaylee. Number 2, the defendant will be sentenced to 10 years fixed for the burglary. The defendant will receive fixed consecutive life sentences for counts the murders. Number 4, the state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. Now, we know that there wasn't anything covered for the families getting to the trial, but when it comes to Dylan and Bethany, because they were technically victims to the burglary, they probably did actually get compensation for moving, because we know that both of them did. Number 5, defendant understands A, the nature of the charge to which the defendant agrees to plead guilty and acknowledges that he is not being coerced into entering his plea of guilty. Everyone that actually has pleaded guilty when innocent, and again, we've gone over several cases like that here recently. Here's the most recent one, and also this one right here about Lucas Anderson. Really, really, really good examples of these kinds of things that happen. They will say, I did not do this under duress. I did not do this because I was coerced or threatened. And it's a lie, because they've been threatened. So answering these questions in court really don't mean anything. It's the same thing as somebody going into the emergency room as a DV victim, actual victim, with the person who's causing them to be a victim and having to lie to the doctor about how they got that bruise or that sprain. It's no different. B, the consequences of pleading guilty, including the maximum penalties that may be imposed and any mandatory minimum penalties. And that C, by pleading guilty, he waives his right to a jury trial, to confront accusers, and to refrain from incriminating himself. Defendant further acknowledges that he is satisfied with his legal representation, has reviewed with his attorney all possible defenses, and by his plea of guilty voluntarily waives those defenses and all claims based upon his constitutional rights. Defendant understands that if were to proceed to trial, he would have a right to appeal, including but not limited to A, any issues decided by the court prior to the defendant's guilty plea, including any rulings on the admissibility of evidence, B, the judgment, including the finding of guilt and any issues regarding the guilty plea, and C, the sentence. Further, the defendant understands that, if were to proceed to trial, he would have the right to file a motion under Idaho Criminal Rule 35 seeking a reduction of the sentence. The defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to ICR Rule 35. But what we've learned from conversations between lawyer and his dad and other attorneys that have come out here, no appeal doesn't mean no appeal. There's actually plenty of options, honestly. Number 7, this is the entire agreement understanding between the parties, and it's signed, and it was actually signed on June 30th. As you can see, everything when it comes to what was going to be happening in the near future has been vacated, and all we have left now is the sentencing, at least when it comes to hearings, because once this is over, the gag order is going to be lifted, and the information is supposed to come out. And what we're expecting to find is something that makes this make sense. So that's what we're going to do. We're going to look, and we're going to look, and we're going to read, and we're going to try to think about what is happening here until something finally makes sense. Because right now, again, I have a million times more questions that I did on Sunday and no answers. Literally none at all. But I want to know what you guys are thinking about this down in the comments, how we didn't get any new information. We didn't get any sort of actual confession when it comes to details, something to validate and prove he actually was there and did this. We got absolutely nothing from him or the state. They didn't have some sort of smoking gun. They didn't have some sort of card up their sleeve. They didn't have anything. And they very much proved that today. So this entire thing is very confusing. Let me know what you guys are thinking about all of this, though, down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out, subscribe to the channel if you have not subscribed already, and please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.